Eddie and Lawyers, a short bite about what is copyright. Copyright consists of an expression of an idea, not the idea itself. So if you are an author and you write a book about constitutions, the knowledge that you're imparting is not protected. The manner of the way you've described your knowledge it's the protection of the expression of the idea that's caught, protected, not the idea itself. So if you're running courses and you have copyright that you hand out, the handouts are protected by copyright. However, if your students take away that information and they regurgitate it and reproduce it through their own skill and time exertions and cost, then that new creation is not protected by your copyright and you can't stop them using it. The form of copyright is that in Australia it covers an original literary, dramatic, artistic, musical work, film or sound. No registration is required, and the duration of protection is generally the life of the author plus 70 years after their death. Copyright is transferred by written contract, wholly or in part, and this is where the exploitation of IP comes through licensing, and it's easily licensed through either exclusive or non-exclusive license agreements. So a right to use your copyright in Australia, a right to use your copyright in New Zealand, a right to use your copyright all around the world. J.K. Rowling granted her copyright for the Harry Potter books to Warner Brothers through an assignment whereby her ideas in her books were able to be used for film, while she retained the copyright in the books themselves. So when you assign the copyright, it can be broken up into its constituent elements. Being a creature of statute, it arises from the Copyright Act, which is part of Australian legislation and is the Copyright Act of 1968. Copyright arises, as I've said, automatically under the Berne Convention for the protection of literary and artistic works. In America, copyright to be protected will need registration. So just don't think that because you have copyright in Australia, where registration is not required, that you may not need registration elsewhere. Now, there are some particular rules dealing with copyright. For example, if you are the author of a literary, dramatic, a musical work, a book, newspaper, journal, letter, diaries, manuscript, plays, or engravings, if you publish that during your lifetime, the copyright, as I've mentioned last, for your life, then a period of 70 years from your death. If you write a manuscript and it were to be published after your death, the copyright period is 70 years from the date it has been published. So if you were to write a musical score, on your death it's tucked away in your iPad and not discovered to the year 3010, and it was then to become a hit, then the people who then owned it would have 70 years from 3010 to 3080 to obtain the copyright from that. Artistic works such as photographs, paintings, drawings and sculptures, but not engravings. They are 70 years after the end of the year in which the creator dies. Sound recordings and films, their 70-year period commences after the end of the year in which the publication first took place. Sound and television broadcasts are 50 years after the year in which the broadcast was first made. There are special rules concerning copyright for literary, dramatic, musical and artistic works that are anonymous or pseudonyms. They are 70 years after the end of the year in which the work was first published. Similarly, if it's unpublished, it's 70 years from the date of first publication. The life in being doesn't rise because the author wishes to remain anonymous or writes under a pseudonym. Works of joint authorship, the same rules apply, so that if you have Lennon and McCarthy writing a song, the 70-year period will last from the death of McCarthy, seeing he is still alive. So it's 70 years from the death of the last of the joint authors. Works made by or under the direction or control of the Commonwealth or a state. The copyright belongs to the Commonwealth or state. It's therefore interesting to note that with employees, if the person is generally an employee, the work will belong to the employer, and that is not the case with contractors. Now, a particular case that I was involved with a number of years ago involved where a woman was engaged as a copywriter and was asked to produce some educational material. She was employed by the Australian Sales Masters, and she was employed not as an employee but as an independent contractor, and she was contracted to write a sales manual and training package. As part of her role, she wrote this particular package, and she thought that she'd be able to earn income through other people, but it transpired that she was not able to make a go of that particular business. So she took on a role as an employee of the Automotive Sales and Marketing Institute. Now, under that particular body, she was asked, funnily enough, to produce a sales and training manual, and having the copyright in the first publication, she used a great bulk of that publication for her new employer. The previous party that had contracted, the Australian Sales Masters, took legal action against ASMI and her, seeking to restrain both of them from using what she had previously produced. They were unsuccessful in their action because, although they had contracted with her to write this particular work, and whilst the work she wrote for them was theirs, they did not get an assignment of her copyright to them. As such, she was the owner of the copyright, and as such, as an employee, she could use her copyright for her employer, and being an employee of a third party, the employer at law took over her copyright for that particular version of the sales and marketing package. So please be very careful when you're asking third parties to work for you. If you wish the copyright or most forms of intellectual property to be yours and not to be retained by an independent contractor, make sure that your contract with them clearly and expressly assigns to you such intellectual property and it's best to expressly mention copyright, trademark, etc. in that contract. If you don't, you can end up in the same situation as the Australian sales masters were, and find that whilst you may have a particular right to use a version of a work, you will not own the entire work, which can make it very difficult for you to expand on that mark and grow it later on.